Onto this, President Cyril Ramaphosa has signed into law the Films and Publications Amendment Act, which took effect on the 1st of March 2022. The rules largely relate to the sale, rental and streaming of content in South Africa on various digital platforms. The act also provides for harsher rules for the distribution of online content in the country, including through social media. For more on this, we're joined by Acting CEO of the Film and Publication Board, Mr. Mashilo Boloka. Thank you very much, sir, for joining us this afternoon. So how did this come to be? What's the intention, really?
Thank you very much for hosting us. This has been a long drawn-out process that started as far back as 2015. We are quite elated that finally Parliament approved this amendment law in 2019, but to allow certain regulatory activities to be completed. That's why there was that time lag between the approval or the signing of that law and operationalizing it in this year. So the idea behind that is that, as you might have noticed, and I think it's not only peculiar to South Africa, if you have noticed throughout the world, I think the problems that we experience on online platforms around harmful content or what you also call harmful or prohibited content has been so prevalent. Hence, there's this attempt throughout the world to kind of deal with that, to hold the online platforms accountable. From Australia to South Africa, everyone has been dealing with that. So I think this is part of that process to ensure that the content that our people are exposed to, brought about by the social media platforms, is not harmful, and neither is it prohibited, but it's in line with the social values of the country.
While some sectors of society have labeled it a welcome move, there are concerns on the impact on freedom of expression in the country. What is it that the everyday South African needs to know?
Well, you see, there's one thing that I think we are trying to do here. In South Africa, there's no way in which we can violate the liberties of South Africans, especially around freedom of expression. So what we try to do through this act is sort of balance the need for freedom of expression with the need to protect the public, including the children, against their harmful content. That's why one of the things that we say is, if you know whether you are a distributor or whether you are an internet service provider, that the content that you're going to distribute is prohibited, rather engage with us or to obtain or register with FPB, Film and Publication Board, so that we can have the certificate. Then there are certain procedures or regulations that you need to follow so that you know that your content is in line with the law. You are on the other side of the law, and therefore, getting penalties.
It also deals with hate speech, saying that hate speech includes words that could reasonably be construed to demonstrate a clear intention to be harmful, to incite harm and promote or propagate hatred against the said person or identifiable group. Please expand on this for us. Intention could be lost in translation.
Well, let me explain this. I think all of us will know how Twitter, not only in South Africa, I think throughout the world, where, social media platforms, including in Twitter, there's what they call the dark Twitter, where a lot of hatred has been spread through that. So that's why I think it's one of those areas that we thought we should rein in as a country to ensure that the content that we do is prohibited. So what we do is there are three categories. We've got hate speech, then we've got what we call propaganda of war. So all those kind of things are the things that are in the new act. But it's not kind of film and publication that's a film and publication board that says this is what we are going to stop you. Sometimes the law allows for any member of the public to kind of lodge a complaint with the Film and Publication Board as the regulator. Then we investigate the matter and hold those that are there to book. And one of the things that we do is we liaise with the distributors themselves. If it means, even if it's a foreign distributor or international distributor, as in this case, you got your Meta, you got your or Facebook or your Instagram and so forth, we liaise through those regulators where this platforms originate or where they are headquartered, so that they can either write them that other side, but for us, you can liaise. But if they refuse, there's a provision for us to take them down as the FPP, because they won't be complying with South African regulation, or alternatively, we can impose a fine. It's only when we have passed that fine stage that indeed we can really go to an extent of taking them down.
Just quickly for us, maybe your response to the insinuation that this legislation, we were not quite ready for it as a country. As you mentioned, we're not the exception to the rule. There's other countries throughout the world that are dealing with this issue, but there's still a lot of loopholes which could open you up to litigation. Your response on that, especially the point that there was public participation, but some of the factors were not considered.
Well, the difficulty with legislation, and actually, let me say the complexity, is that there are multiple interests that are advanced. You've got the commercial interest, but what we are guided by from a regulatory perspective, and I think from our own shareholder, the Department of Communication and Digital Technology, as the policymaker, and together with Parliament, what guides them more than anything else is the what you call public interest. If that is in the public interest, the public interest principle trumps over any other, whether it's commercial and so forth. So we try to balance the two. That's why we say it's not like a carte blanche. In the law, there are certain remedies that we provide or process that we provide to say that if you are not happy with the decision that we take, we have in place in the law what you call the appeals tribunal, where you can lodge a complaint against the decision that we make as the regulator if you are not happy. And then if you are not happy, and the appeals tribunal is an independent body, their job is to kind of review the decisions that are made by the Film and Publication Board, together with a new structure introduced by the law called the Enforcement Committee, which is introduced by Section 3 of the Amendment Act. So they are the ones that do the enforcement and issue penalties. And then if you are not happy, you go to the appeals tribunal. Still, if you are not happy or you don't get joy from the decision of the appeals tribunal, you can exercise your rights through the courts of this country. So that's I think the remedies that you've provided internally, and without taking away the rights for anyone to exercise their rights beyond the FPP or even exercising their rights through the court. So I think what we are trying to do is, and you can see when you try to compare South Africa, we are very considerate. I think our approach has been very flexible compared to other countries where they just shut down. It's as simple as that. With that, it's clarity. It's also there's a process in case you're not happy, so that it's not a kind of draconian approach to it.
Mashilo Boloka is the acting CEO of the Film and Publication Board. Thank you very much for those details.